going to be a little bit of a choose your own adventure, all right? So, do you guys want to start with random drug testing or OSHA update? Because we can't do drug jeopardy until after we do the other two. So, hands for random drug testing? Oh, yeah, okay. So we're going to start with random drug testing. Okay, I like this clickbait title. If you look at Huffington Post or BuzzFeed, it's always like, he institutes drug testing policy, you won't believe what goes wrong, or she does this with 3 pallets or whatever. I've done that. I've done really cool pallet crap. So we get this question quite a bit. I'm hoping you all do it right, but in case you don't, and even if you do or don't have a random drug testing policy, I want to cover kind of the legal issues that come up with random drug testing should the question comes up. There's different types of drug testing. I'm not going to touch on all of them because it would take kind of a long time to do that. So we're going to talk about random drug testing, okay? Let's see if I can. I have contacts on so I can see you. But I would need glasses on so I could see this, but then I couldn't see you? Yeah. Okay, so there's lots of different types of drug testing: pre-employment, reasonable suspicion, random post-accident return to duty. We're going to talk about just the random drug testing, okay? I will just say this, if you take away nothing from this afternoon, if your county has a random drug testing program that applies to all of your employees, you probably need to change it, okay? I ask questions in different, I'm not gonna put anyone in the hot spot, but some folks will say, well, we do this or we do this. If you have a policy, so you need to go back and take a look at your policy, even if your practice isn't, you don't even want it written in a policy because you don't want then to have to say, it's written in our policy, but we don't actually do that. Make sure that what you do matches with what your policies are. Maybe that could be your risk management takeaway for today. I don't know, 2 of them at least. So if you have a random drug testing policy that applies to all of your employees, probably boot it. Why? Well, you are all with local governments, and local governments have a different level a different standard that we have to abide by, because your government, the Fourth Amendment protects people from unreasonable searches and seizures made by the government. It doesn't protect people from unreasonable searches and seizures from private industry. So if I worked at Walmart, they could say, Tim, we do random drug testing here. Occasionally you might be tested. Yeah, in fact, they can do that. You folks can't, all right? So, some background, just groundwork. The U.S. Supreme Court has held drug testing as a search within the meaning of the Fourth Amendment. So, if a drug testing is a search, and we're local governments, that means we can only search someone if the search is reasonable under the Fourth Amendment. Right now, you ought to be seeing, that red word. You know that's going to be on the test at the end of the chapter. It won't be here, but those words are what keep lawyers in business, because you can see that we're going to be, in lawsuits, the question is going to be, well, let's define reasonable. Let's define these terms. And then attorneys get to do it a lot more expensively than we get to do. What is reasonable? It depends. So the courts have said it's a balancing act. The employee's Fourth Amendment right to privacy can be outweighed by the government's interest in drug testing, right? So we've got privacy and the government's interest for a safe workplace. I can't do this. I have to talk here. Okay, so when can you have random drug tests on? If the government's special interest, again, we've got these bold words, they'll be on the test. Special interest is compelling, and the intrusion minimal, a public employer may engage in random drug testing. So we're going to have to do 2 things. We're going to have a compelling interest, and we're going to have to be able to articulate what that compelling interest was, and then we're going to have a minimal intrusion, all right? If you are so inclined to see a really beautiful wrap-up of the history of random drug testing with local governments, Krieg versus Siebold, it's a 2007 case, summarized 20 years worth of drug testing, random drug testing laws within the United States. So it's very nicely concise. The reason that this case is very special to us is it was ours. Siebold was Mayor Siebold here in Indiana, and Krieg sued the local government, the city, saying that the random drug test was violating his Fourth Amendment right. We won. And what we got was a really beautiful history and outline that you can look back on, and it touches on all the times that you can random drug test and all the times you can't. So I'm going to try to kind of cover that, okay? Okay, so in that case, it restated what I've kind of covered, that suspicionless random drug testing is permissible when it serves a special governmental need. Good. And then it says when an employee holds a, I should have done bold here, but I was quoting the court here, safety-sensitive position, and then this was their term, fraught with such risk of injury to others that even a momentary lapse of attention could have disastrous consequences. All right, so if you're wondering, what's that balancing act? What am I going to have to articulate? What am I going to have to say could happen if an employee might be on drugs? I would have to say that it's a type of job that is so safety sensitive that even a momentary lapse of attention could have disastrous consequences. I have some thoughts right away when I read that, because I think of driving, right? Just anyone driving, but we'll get back to that, because no, just folks who drive, nope, that's not safety sensitive. So what types of jobs would allow random drug testing? So again, in that case, they outlined a whole bunch of stuff where previous U.S. Supreme Court decisions had been made and Seventh Circuit cases, and that's Illinois, Indiana, Wisconsin. That's where we are. That's the playground we're in. And I kind of summarized this. I didn't footnote it and lead you back, but if you were so inclined, you could look at that case. So employees working with large mobile equipment like dump trucks, plows, front-end loaders, or backhoes. Other heavy equipment operators like cranes, forklifts, or tractors. Oh, and how about law enforcement, firefighters, EMTs, corrections? We got those, right, in counties? So there's a number of folks that fall into that category of safety-sensitive positions. And those folks could be likely candidates for counties to do random drug testing for, okay? So now we kind of know who falls into the maybe we can drug test. Let's look at the ones where we probably shouldn't drug test. How about accountants, attorneys, clerks, clerical workers? And the court said, people driving cars or vans, just carrying stuff, okay? Not carrying people. They're not ferrying people around. They're just delivering stuff. These folks, the courts have already said, no, 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 no random drug testing for them, okay? Yes?
What about transport or RDS?
I would say you are transporting people, and the courts have said stuff. Actually, the real word that they used was documents. So I would imagine that puts them in a different category. You are ferrying people. Yeah, yeah. Do they have to have a CDL to do that? To transport, like the type of vehicle they're driving? No, they're not like driving a bus or anything. Okay, because there's another kind of preemption here. Now remember, I'm not going to talk about the other types of drug testing, but I will just say, keep in mind, none of this precludes you from having reasonable suspicion testing, drug testing, okay? You just have to know the language, right? So if you're going to do reasonable suspicion testing, you need to be able to articulate it and say things like, she was walking with a stumbled gait, her eyes were glassy, she had slurred speech, not she looked drunk, right? You have to be able to be specific. I usually make a joke there about my kids, but I'm not today. Yeah. So the courts also said, and this is like, it kind of shocks people, a general interest in having a safe workforce is not considered sufficiently is not considered sufficient to justify random drug testing. So if you say, hey, we want to just do random drug testing because we consider all of our positions safety sensitive, the courts go, no, can't pull a fast one. You can't recategorize people. And so they said, this was their words, an across-the-board policy of random drug testing would not be justified by a special need and would violate the Fourth Amendment. So you just have to be able to say what that special need is. Like, this is extremely dangerous, this could kill people, this could hurt others, that type of thing. Probably, so AIC had already reached out to me and said, would you be a speaker and talk about some stuff at the legal and ethical training, and what do you think you want to talk about? And like the next day, I got an inquiry from a county saying, we do random drug testing for everybody. Is that okie doke? And I was like, you know what we're going to talk about? We're going to talk about random drug testing. So if you guys got it right, great. But I think just kind of a background and a reminder of why random drug testing is a no-go for local government is important to cover. One of the things that I think happens is we get people in, county commissioners who come in from private sector and they want to bring their private sector experience. And they say, hey, you know what we found was really helpful? Lowered our work comp incident rates and lowered our insurance, and it was really good. We did random drug testing and it really kept everybody on their toes and it had an immediate effect. Yeah, it does. But unfortunately, you folks can't do that. So the Supreme Court has given guidelines, and a lot of this is, again, that case I originally mentioned, the Craig versus Siebold, outlined some of these things. These are some things that you might consider when you are doing random drug testing. So if you're doing it, make sure you're kind of check these off your list, right? Give employees notice in a handbook. So it ought to be somewhere. It ought to say, we do random drug testing. Carry out collections of specimens in a private manner. Oh, this goes back to that minimally intrusive thing. I think for the most part, when you contract with a third-party entity to do your drug testing, you're in okey-doke hands, right? They know what they need to do to make their drug testing be legal. Back in the day, some entities kind of were doing their own thing. I would advise you not to do that. I think that you start moving away from you start breaking that privacy barrier, probably ruining the minimally intrusive, and kind of puts you in a dangerous zone. Only screen for specific drugs. So you don't want to like come in and say, oh, we found something that you don't need to, a little bit of privacy there. Use reliable and accurate tests. See note regarding using third parties. And don't require employees to list all personal medication they have taken in the last 30 days. So for instance, what some entities have done is they say, hey, we're gonna do this random drug test, and as long as you haven't done anything bad, you haven't done anything funky, it's okay. What we'd like you to do is just write everything you've taken in the last 30 days and just put it on this piece of paper, and we're good to go. And then as long as what you've taken matches that, we're good. What's the problem with that? You don't need to know if I'm on some medication. It's not your business to know whether I'm taking Coumadin or Prozac. If it's not germane to the safety and my job position, that's a privacy issue. Okay. All right. So remember this. You guys have a higher duty to employees than private employers because of the Fourth Amendment. It applies to governmental actions. We've got that balancing act, weighing government's interests while considering job duties, need for testing, nature of the work environment, and safety. One of the things that I've seen is people, like I said, somebody comes in and they go, hey, we want to use, here's a drug testing policy. Let's use theirs. And it's from when I was with the bank or when I was at the grocery store. Don't do that. If you do use a sample policy from somebody, probably it should be from a public sector entity, and you should also get legal review on everything that you do. Any policy that you're going to implement and put in place, have legal review that. Okay, so that was our Choose Our Own Adventure number 1 on random drug testing. Any questions? All right, so you guys are all good. Random drug testing, we're good.
Medical people, say we have a clinic, we have the health department, like the nursing staff, like those people need to do this.
Do you know what? I had that question come up. And so I went to an attorney and said, hey, are there other classifications where people have been specifically called out in the Seventh Circuit? And he said no. So now I'm not saying no to you. I'm just saying that right now that's an unsettled area. I think that, again, you'd have to be able to articulate what the safety-sensitive nature of that would be.
They have access to drugs, they have to make decisions right now. I was concerned that we have mental health facilities as well.
Mm-hmm. Mm-hmm.
How about the 911 center?
I think they would I think they would fall into the momentary lapse. I think we already know that law enforcement, corrections, and what were some of the other ones? EMTs. I think dispatchers would fall into the momentary lapse, right? You got to be able to act quickly. I think probation might. Again, I would kind of take that Krieg versus Siebold, and I'd go to your county attorney and say, if we're going to do random drug testing, we're going to put these people in. You need to be telling us if we're pulling the right people in or not. That's my suggestion. That's random drug testing. Because we're going to move into we're going to go over to the Osha update. And really, the Osha update is to talk to you about another type of drug testing. But we'll talk about a couple of other issues as well. So we got a little case study. So it's March 29th, and you learn that an accident involving a public works employee occurred at 3:30 the day before. The injured employee drove themselves to the hospital. They were admitted overnight. The injured employee and two employee witnesses, none of them told anybody about that until the next day. Okay? So that's our scenario. A, can you drug test the employee? B, can you discipline the employees for not notifying management of the accident or injury sooner? C, do you have a safety bonus program? Would this accident impact it? Like now they're in the highway department. Now the highway department's not eligible for the quarterly drawing. We'll get to all that. All right. So I'm going to talk about the new rule, kind of, because it was passed in 2016. But it's not like everybody gets, the OSHA up-to-date newsletter. I actually do. There's a thing called the OSHA up-to-date newsletter. And so OSHA kind of tries to tell people when things happen. So this one was interesting, though, because the law said, hey, employers are going to start electronically submitting their injury and illness data to us. That's already on your OSHA 300 log. Certain employers are going to send that to us electronically, okay? That's what the OSHA regulation said. And if you're curious, that's 29 CFR 1904. However, so the juxt of that OSHA regulation was to make sure that people were reporting accidents and injuries. So, OSHA says, hey, we don't want employers disciplining employees for not immediately reporting work-related illnesses or injuries. We also don't want incentive programs that are going to deter employees from reporting injuries. And we think that a blanket automatic post-accident injury drug testing program is going to have a chilling effect on employees reporting their accidents and injuries. So, these three things that lots of employers have, like a safety incentive program, if you get into an accident, you immediately get drug tested. Oh, and if you get injured, you better tell us by the end of the shift or the beginning of the next shift. Nope, nope, nope. Those policies are gone. Yes, sir.
So how does the post-accident prohibition on drug testing square with the reasonable suspicion drug testing?
We'll get to that, all right? They're different. And OSHA kind of wants you to have some reasonable suspicion is what it comes down to. And I'll get to like when you, so some entities I have seen they've had I'm kind of jumping ahead, have post-accident drug testing rules that say any injury that any accident that results in an injury, you must get drug tested. Or any accident that results in first aid or medical care, you must be drug tested. Or any accident that results in $500 worth of property or auto damage, you must be drug tested. So there are instances where those situations might not actually have been caused by the employee, right? OSHA brings up, for an example, a bee sting. So, or a rear end accident. If you were rear-ended and the damage to the vehicle is over your $500, it meets the threshold of automatic drug testing? So it gets right to your point of reasonable suspicion testing. And OSHA actually they gave guidance, and they gave a specific sentence that I want to use their language, where they talk about there needs to be I forgot their word, logical assumption that an employee, that employee drug use could have contributed to this accident, okay? So like a bee sting, they're saying no. A repetitive injury, no. A no-fault vehicular accident, no. Those would not be appropriate times for post-accident drug testing. And the real word that you got to remember here is this blanket word. So if your policy says we post-accident drug test in this big blank situation, you're probably at odds with the OSHA regulation. I would not do that. I would change that. Okay. So even though, this regulation that OSHA passed was all about reporting. So the drug and alcohol testing was not even mentioned in the rule. But then OSHA came back and said, oh, you know what? We think post-accident drug testing can be retaliatory. And this whole regulation is all about not retaliating against employees for reporting injuries and illnesses. So we can't do anything that's retaliatory to these poor pumpkins. We need them to just come on in and report their injuries and illnesses, which is true and good. So the idea is, if I hurt myself at work and I was under the influence of drugs or alcohol, I might not want to come running in and reporting it either quickly or at all. Okay? Okay. Again, so I want to go back so you understand why it is that OSHA is saying this. OSHA is saying drug testing or the threat of drug testing as a form of retaliation against employees who report injuries or illnesses is what they don't want. They do not prohibit all post-accident drug testing of employees. It's a very big difference. Also, if you have to drug test as part of a state or federal requirement, this does not affect that. So if you have CDL folks who get in accidents and they have to do post-accident drug testing, you still continue with that. Okay? This doesn't preempt that. So your drug testing policies should limit post-incident testing to, this is OSHA language here, situations in which employee drug use is likely to have contributed to the incident. This is another good one too. And for which the drug test can accurately identify impairment caused by drug use. Because I see more problems down the road for this. For instance, we can test for THC in the system, but THC, which is from marijuana, stays in the system for up to 30 days. In fact, the heavier you are, the more likely it stays in. So I'm cooked. So the real question is, with our guy who got injured in our case study, if we do a drug and alcohol test more than 24 hours later, are we going to be able to determine that he had impairment caused by drug use? Probably not, because we won't be able to tell if he had been drinking. His alcohol will be out of the system. And if he has THC in the system, will that really point to any impairment, or could it point to drug use 30 days ago? So I see that being something that's problematic until we have a really good impairment test for THC, not just presence of THC in the blood system. And there are companies working on that, and I'm watching them, because as soon as one of them breaks through, I'm investing a ton of money in that, because they're going to be doing roadside pot tests, and that is going to be, that stock's going to be skyrocket. Okay. Two companies. One is, you'll get a kick out of this, Blows, B-L-O-Z. But my money is on LifeLock, which already makes the roadside alcohol breathalyzer test. So, you know, I think the horse that's in the lead is going to be LifeLock. But I'm looking at both of them. Okay. When is it not going to be reasonable to drug test? These are OSHA's examples. A bee sting, a repetitive strain injury, something caused by a lack of a machine guard. Not that an employee forgot to use the guard, but there was no guard on the machine. A machine or tool malfunction. And OSHA says, again, remember, we don't want to deter the reporting. Such a policy is likely to deter reporting without contributing to the employer's understanding of why the injury occurred, or in any other way contributing to workplace safety. I do get a kick out of this, though, because I have a 29-year-old, a 26-year-old, and a 22-year-old. Two of them are boys. Substitute the word stupid for that. And I'm telling you that if I told my kids to go mow the lawn and one of them came in and said, I have a bee sting, I would go, what did you do? Because it's very likely that the fact that they were brain-addled from a variety of things, and the 29-year-old lives in Denver, so figure that. It could definitely have been poor judgment because of impairment of some type of substance. But, you know, I'm not going to argue with OSHA. I think if you're testing for bee stings here, you're going to have to be able to say, we think that a reasonable person would not have poked the bear, right? I think that type of thing is going to have to happen. Okay, so again, I know I'm kind of maybe really pumping this in, but OSHA's discussion on this was to say retaliatory adverse action taken against an employee simply because they reported a work injury or illness is what they want to not have taken place. But you can still discipline employees for violating safety rules, all right? So the question would come up, what about our 3 employees, okay? One of them got injured, there were 2 witnesses, no one reported. If there was a policy that said you needed to report any incident that ended in property damage, first aid, or hospitalization, and you need to notify the employer as soon as practically possible. And I don't know, what would that be? You know, would that be before the shift was over, before the next shift began? I think you need to consider that. Here's the catch. The catch would be, and I don't know if I'll get, I don't know if I have that language in here, but I know one of the things I found was, let me just jump ahead real quick. So one of the examples they gave was in a situation where there's an accident, one employee gets hurt, but 2 were there and 2 others witnessed it, you better treat all 3 of them the same. In other words, you probably, if you think that you should drug test, maybe you would drug test all 3 of them. And if you're going to cite them for not notifying you within your policy, whatever your policy says, they have to tell you within X amount of whatever, all 3 of them should have the same thing, not just the person who had the injury or illness. See how that works? So that otherwise you are retaliating against the person with the injury or illness. So your policy should be written such that it would be an employee's responsibility to report injuries, illnesses, or accidents, even if they weren't the one injured. Yes?
So if the injured person is in a coma, the other 2 people have the same length of time until the guy gets out of the coma?
No, I don't think so. No, it's the exact opposite. I think the burden falls on them, and then your ability to discipline them for not reporting is just as strong as the employee who's in the coma. Do you know what I'm saying? So in other words, if that kind of points out the error of having a policy that says only the injured employee is the one that needs to come forward. I think somebody has to come forward. Okay. So, key points. You can have post-accident drug testing. OSHA will not and cannot issue citations for drug testing required under mandatory state laws or drug-free workplace laws or federal regulated programs. So, if you're already doing random drug testing for those other issues, you can continue with that. The regulation is going to require a reasonable basis for employers to perform a post-accident drug test. What I think is, as this gentleman pointed out, I think you ought to go to a reasonable suspicion testing. You've now eliminated the post-accident. The accident would just be something that might prompt you to have reasonable suspicion. But then I think you're going to need to articulate, like, we don't see that any other employee would have put their hand in the wood chipper unless they were perhaps on some type of hallucinogenic drug. I think you're going to have to be able to, use reasonable suspicion language inserted in. In fact, if you go and if you just Google OSHA post-accident drug test, you'll find a whole bunch of stuff, and it'll link you at some point in time to the OSHA website, and you'll find language that you could just cut and pull right into your own post-accident drug testing policy. All right. Because you're going to have to answer this question. Is there a reasonable basis for concluding that drug use could have contributed to the injury? That's the question you've got to be able to answer. And if your answer is yes, go ahead. Post-accident drug test. Remember about the employees involved in the incident? Are they also drug tested too? If 3 of them were horsing around and one of them gets injured, I'd drug test all of them. If you had a reasonable suspicion to think that they were all whatever. Do you think there's a heightened interest in determining if drug use could have contributed to the injury due to the hazardous nature of the work being performed? I think this goes to your health care folks and having them drug tested if they're, I think we definitely have a heightened, what's OSHA's language? Heightened interest in determining if drug use could have contributed to the injury. I wouldn't want any of my medical folks to be on some type of drug. Okay, so what is it you need to do? What's your takeaway? Review your drug testing policy or policies. You remember, so if you've got pre-employment, post-accident, random, reasonable suspicion, return to work, there's lots of situations in which you can do drug testing. What I've covered in the first part was random. This is post-accident, okay? You want to remove language that says anything about blanket testing. Make certain the testing only occurs if there's reasonable basis to assume drug use could have contributed to the accident. So I think one of the things that you should also do, and I don't know if you guys do this, but there's good stuff out there. Look at reasonable suspicion training for your supervisors. There's videos out there. There's stuff out there where you can, get people alerted to the fact that if somebody have a reasonable suspicion, you ought to give them the tools and the language so they can say things like, Harry seemed to be walking with a stumbled gait and glassy eyes and slurred speech. Susie just seemed to be really lethargic and eating Cheetos. I think you need to alert people to be able to articulate so they don't say things like, he looked high. The goal of the OSHA regulation was really nothing to do with post-accident drug testing, eliminating incentive programs. Oh, we didn't talk about the incentive program. So what about that incentive? Do some of you folks have like quarterly incentives or drawings or end of year OSHA? No? All right. Sometimes people do. That's kind of I'd boot that. OSHA's point in all of this was to have a procedure that's reasonable and doesn't discourage employees from reporting injuries. They did say a policy which demands employees report an injury immediately or they're disciplined is improper. So look into your policy. If it has that immediate word in there, I'd boot it out. I'd talk with my attorney about what would be reasonable, like end of shift, next shift. That would make some sense. OSHA is more likely to determine that your reporting procedure is compliant if it allows an employee to report an injury within a reasonable amount of time, but perhaps no later than end of shift or within 8 hours, whichever is least. Whichever's later, sorry. And I pulled that right from OSHA guidance. So they're saying end of shift or within 8 hours, which is a heck of a lot faster than before next shift. The safety incentive programs, we don't need to talk about it, but basically an employer cannot award incentives based on the number of injuries or illnesses that are reported during a certain time period, which is what everybody's done for a million years, right? You can't do that anymore. I won't go into incentives. Won't go into incentives. Oh, OSHA, they're getting serious. They had their first penalty increase since 1990. They increased their serious penalties from $7,000 to $12,000. A willful or repeat violation increased from $70,000 to $124,000. And there will be yearly adjustments made for inflation from now on. So OSHA's going to be, when they take a bite, it's going to hurt a little bit more. All right, any questions?